Native nations predated the United States. We were here first. Continued to exist through all of America's history and still exist to this day. If you remember back to like ninth grade civics class for U.S. history, there was this debate with the Federalist Papers and stuff like that. How much power do we put in the federal government and how much to state governments? And the U.S. Constitution is structured, for both better and worse, to say that all power is inherently held by states, except for defined federal powers, like an army for the common defense, system of taxation and laws, so forth. And so dealing with natives is one of those defined federal powers, right? So the Trade and Intercourse Clause says only Congress, meaning only the U.S. Congress, shall regulate trade and manage affairs between the several states and various Indian tribes. Between that and the Treaty Clause, which says treaties are the supreme law of the land, the feds deal with native nations. Now that's what the Constitution says. There's been a lot of court cases to unpack that have shaped and influenced that over time. The Marshall Trilogy would be a famous example of that, in which natives won their court cases, affirming their inherent sovereignty, but Justice Marshall wrote in his ruling that they are native nations, but they are domestic, dependent nations, even using language like little red children to their great white father. And then that word stuck. So it set up this ambiguous second-class citizenship, but still the essential tenets of native nationhood predating the United States on a nation-to-nation relationship with the federal government persisted. Now, there were other ones too, plenary power doctrine and others, but even with the Crow Dog case, you had a native kill a native in a native space and could not be, justice was handled according to Lakota custom in that case, but the effort to have him tried in a state or territorial court for murder failed because the state had no jurisdiction over him. So then there were efforts to pass federal legislation to intrude on tribal sovereignty, what they called the Major Crimes Act. So cases of murder, rape, and then the rest are all property crimes, arson, larceny, things like that. Then the U.S. federal government will assume jurisdiction. So there was this creeping intrusion into native nationhood. So you will notice tribes don't keep their own armies, for example. There's certain attributes of sovereignty that you might expect from a truly sovereign nation that are blunted in the American experience for native nations. However, most of our lives today are governed by state laws. Marriage, divorce, now abortion, things like that. So, those laws do not have the same blanket effect over all native people. And there have been other intrusions into sovereignty, but for the most part, you could think of it like this. If a state has a law that says gaming and gambling is illegal, except for Powerball, pull tab, and church bingo, then those laws will not apply to a native nation, and they can create a casino complex regardless of what state laws say, because they are governed by tribal laws. And so in many states, that is exactly what has happened. And you can almost use your imagination as to the things, like when it comes to business, commerce, pharmaceutical regulation, most of this stuff, tribes could do all kinds of things. I think the main inhibition is just the imagination for what they could do. That doesn't mean that all efforts are advisable. In some states, tribes were early legalizers of recreational marijuana before the state around them did that. Whether that was politically advisable or not is a separate debate, but it's within their authority to do so. There have been experiments with federal legislation to impose state criminal jurisdiction over tribes, so a handoff from the feds to the state. But that law, Public Law 280, applied in certain states, not everywhere, and did not affect the civil jurisdiction. So you still have a lot of life governed by tribes. And the jurisdictional issues can be complex, where you have checkerboards and native and non-native people living within the same space. I'm not sure if you're familiar with this, but the sexual assault rates in America are very high. Depending on which studies you look at, Some will say as few as 25% of women in America will be sexually assaulted. The sexual assault rates for Native people are twice the national average, 50%. Most crime in America is white on white and black on black and things like that, but crimes of sexual violence directed at Native women are predominantly perpetrated by white men. And so, for the most part, the legal apparatus has said tribes have jurisdiction over their own members, but not anybody else. So white men could come onto a reservation and prey with impunity. So the effort to address that has been handled through the Violence Against Women Act, and it's gone through many different iterations, but the problem until very recently was that this was a piece of legislation that would bridge some of these jurisdictional shortcomings, but it would have to be constantly reauthorized by Congress. And it would get held up in the Potomac two-step as people are fighting over things like wanting to get a pipeline pushed through, worried about tribes being an impediment to pushing through the pipeline and holding up the VAWA legislation just to stick it to the tribes and stuff like that. So more recently we had a no sunset clause put in on some parts of the VAWA legislation, but that piece of legislation needs to be strengthened and expanded to further cover the issues with missing and murdered Indigenous women and so forth. So again, layers, but you know, like I live in Minnesota, all of the tribes, like we understand the inherent nature of sovereignty. We have a nation-to-nation relationship with the federal government, but we still talk to the states because we got to get along and got to get stuff done.